Imagine a situation where a small quarrel between a husband and wife escalates, leading to the wife filing a complaint under Section 498A of the Indian Penal Code or IPC. Is it fair that even minor acts or misunderstandings can lead to such serious consequences? Can these trivial acts by a husband or his relatives be considered as cruelty under Section 498A? In today's video, we are going to dive deep into this intriguing and often misunderstood aspect of Indian law. We'll explore the nuances of Section 498A, the intent behind it, and how the courts interpret minor acts of the husband or his relatives. Here's what we'll cover in today's discussion. First, understanding Section 498A. We'll briefly explore what Section 498A of the IPC entails. 2. What constitutes cruelty? We'll define cruelty in legal terms and look at how courts interpret it. 3. Judicial interpretation of minor acts. We'll discuss key judgments where courts have examined whether minor acts or trivial incidents fall under 498A. 4. Recent developments and misuse concerns. We'll look at recent updates on the misuse of 498A and how courts are addressing these concerns. Let's break down each of these points to understand this section better. Section 498A of the IPC was introduced in 1983 to protect married women from cruelty by their husbands and in-laws. It is a non-bailable cognizable offence, which means that accused can be arrested without a warrant and denied bail. The law was enacted to safeguard women from harassment, dowry demands, and physical or mental cruelty. But what exactly is cruelty? How do courts differentiate between a serious offence and something minor? Cruelty under Section 498A isn't just about physical violence. It includes any willful conduct that drives a woman to suicide or causes grave injury or danger to life, limb or health, mental or physical. But this definition raises a crucial question. Do minor acts like verbal spats, occasional arguments or petty differences fall under this section? Let's delve into some landmark judgments where courts have drawn a line between serious cruelty and minor trivial acts. First case law is Sushil Kumar Sharma versus Union of India. The Supreme Court emphasized that Section 498A should not be used as a tool to harass husbands or his relatives. The court noted that while cruelty is a valid ground for invoking 498A, trivial acts or normal wear and tear of married life should not be considered cruelty. The second is Arnesh Kumar versus State of Bihar. In this case, the Supreme Court issued guidelines to prevent the misuse of Section 498A. The court observed that in many cases, trivial acts are blown out of proportion and used to file complaints under 498A. The judgments emphasized the need for a preliminary inquiry before arresting the accused to avoid harassment. Third is Girish Pandurang Kale versus State of Maharashtra. The Bombay High Court clarified that occasional outbursts or minor disagreements between a couple do not amount to cruelty under Section 498A. The court stressed that there must be a clear intention to cause harm or harassment to invoke this section. These judgments show that the courts are cautious about categorizing minor incidents as cruelty. The intent behind the husband's or relative's action play a significant role in determining whether it qualifies under 498A. Section 498A has been a subject of much debate due to its potential for misuse. In recent years, there have been instances where frivolous cases were filed, leading to unnecessary harassment of the innocent individuals. Recognizing this, the Supreme Court has issued several guidelines to curb the misuse of this law. For instance, in Rajesh Sharma versus State of Uttar Pradesh, the Supreme Court suggested setting up family welfare committees to scrutinize 498A complaints before any action is taken. However, this decision was later modified, acknowledging that not all cases of cruelty can be considered trivial and that genuine complaints should not be diluted. Moreover, The Ministry of Home Affairs issued an advisory in 2014 stressing the need for careful scrutiny of complaints under 498A to prevent false allegations. This move was aimed at ensuring that while the law protects women, it does not become a tool for exploitation. Let's recap what we have discussed today. First, Section 498A's purpose. It was introduced to protect women from cruelty, but not all minor acts qualify as cruelty. 2. Definition of cruelty. The courts have made it clear that trivial acts without the intent to harm do not amount to cruelty under 498A. 3. Judicial guidelines. Various judgments have highlighted the importance of intent and the need to avoid the misuse of Section 498A. 4. Recent updates. Courts and the government are taking steps to balance the protection of women with preventing misuse of the law. In conclusion, while Section 498A is a powerful tool to protect women, it's crucial to ensure that it is not misused for minor issues or misunderstandings. The courts have been vigilant in ensuring that only genuine cases of cruelty are prosecuted under the section. Understanding these nuances helps in appreciating the delicate balance the law tries to maintain between protecting rights and preventing misuse. If you found this video helpful, don't forget to like, share and subscribe to our channel for more insights into Indian law. Have any questions or need further clarification on Section 498A, drop your comments below. We'll love to hear from you and help you understand your legal rights better. Stay informed, stay empowered. Bye-bye.